What's up, Taylor Gang? In the building today. Looking good. I'm late today, but it is what it is. We about to get into it. We still about to get this show on the road. We know Karen Reed ain't starting on time, no way. We know they ain't starting on time. It's gonna be a sidebar before we even get the day started. It's gonna be a sidebar before the day even. Oh, court is not taking place due to unavoidable circumstances. What? Child, they say they know court today. They didn't cancel court. They didn't cancel court this morning. I mean, after yesterday, after Yuri testimony, I don't know what. Okay, L, because what's really going on? What's really going on? Because it's given after Yuri's testimony, something crazy didn't happen. Now I didn't froze up. So we can do it. We can actually do docket watch. So let me go get my docket watch thumbnail. I will switch it up. We're gonna edit this. We're gonna upload another thumbnail and we're gonna do docket watch. We're gonna do us a little. That's crazy now. That's what I'm saying. Now Yuri didn't got up there yesterday tripping. We don't know if it was Brian Albert, if it was Brian Higgins that then drove over to the Canton PD department walking through there. Now, I will say the face did look like Brian Higgins. Sorry, y'all. I need to get my nails done. You know how you want to sneeze, but like your nose just feel tingly? That's what my nose is feeling. Just lying. He up there just lying. He don't want to identify nobody. He just really talking about he don't know what happened with the video camera footage yesterday, but we know that one angle shows Proctor over there by that tail light, and the other angle is missing the footage. So if the math is supposed to math and it's math in the way that it math, Proctor was messing with the camera. Proctor was messing with that tail light. He was messing with that tail light. So I don't know what unavoidable circumstances mean. Maybe there was a juror who wasn't there. Let me get on Twitter and see if I can find us a little tea on what's going on here. Also, if you haven't heard, Melly's bond was denied on yesterday. Yes, Melly's bond was denied. Now I'm getting ready to post I'm getting ready to post the content. That's why I had to get my little self together because I was looking bad in the video yesterday. So I'm about to post the content on why Judge Fine decided to decline or deny the bond, and we're going to talk a little bit about that appellate issue or the appellate arguments that's going to be coming up. Now, Judge Fine trying his best not to delay the Melly trial. He trying his best. He said he didn't care what was going on. He was not pushing that trial back. But the oral arguments are scheduled 6 days after the trial is supposed to start, and it's related to the suppression of the evidence. So I think it's kind of inevitable at this point that that trial is going to be moved. That trial is going to be moved. You know. Okay, so everybody is only reporting on unavoidable circumstances. Nobody is reporting on anything else. All right, so that is pretty much it. Good morning, Shay. Good morning, Beta. Good morning. Bama girl is in the building, y'all. Make sure that if you came in that you went ahead and you hit that like button. If you haven't done so already, make sure that you are subscribed to our channel. It's absolutely free. Subscriptions are absolutely free. In the event you do want to participate in something that costs, you can actually get a membership. I think they're like $2.99, $1.99, something. I don't know, but you can get you a membership to be a part of the Taylor Gang, where you get exclusive access to emojis. And I'm gonna try to figure out, now that I got time, I need to figure out what more are we going to do with our memberships, right? I want to open up some more exclusive stuff for y'all. I do know that once I start college, once I start law school, I'm going to be releasing some exclusive content only to my members. So that is something to come for sure. For sure. I already have that mapped out. But since the current retrial is delayed today, we are going to do a docket watch. Y'all know how we like to go and sit in folks' courtrooms. Judge McBurney is in trial today. Who else we got out here? We got Hillary. We got traffic court. Let me know what y'all want to watch. We can watch traffic court. We can watch Mr. McBurney. Was that McBurney today? We can watch Judge McBurney in trial today for somebody. That's kind of all that's up. I would actually expect more court streams to pop up in the next hour at around 9 o'clock Central Time. I think I'll see more of those pop up. So Shay said she wished she could become a member. I know, Shay. You like the one of the number one Telegang members, and so I am a little disturbed by YouTube and their inability to allow you to become a member. Like, they need to get their life together. And D Wood, they didn't kick D Wood out the gang too, out of the technical game, but we know he's a part of the real game. We know he's a part of the real thing. So. Okay, y'all. My application got updated again yesterday. I'm anxious, y'all. I'm so anxious on this school. But I do feel like it's a good thing that I haven't been like flat out denied. Like, y'all didn't touch my application twice already. So okay. I feel good about it. So let me see. Like I said, let me figure out whose court we're gonna sit in. I'm just rambling right now. Oh, this is civil trial, y'all. We're gonna. I'm gonna tag it up. Let's get it. We're gonna sit in Judge McBurney's courtroom today.
Great. All right. While you're doing that, we'll get on the record. Now that our court reporter made it through the fortress. We are here on 2023 CV 386362. It's Christopher Pope versus Marta. Mr. Pope is here. He is pro se. Ms. Lewis is here representing Marta, and Marta's agent, Mr. Ennis, is here as well. Yesterday, we picked a jury very efficiently and then went through a lengthy discussion on motions in limine that Marta had filed. I asked for jury charges. It looks like both sides have gotten them to Ms. Niles, so she can work on a draft jury charge that I'll circulate once she's done. We left hanging a couple of questions that the two sides were going to work on over the course of the evening that I want to revisit. And let me do that so we've got a good view of the courtroom. And we had one development with a juror that I'll address you all in a moment. Let's start with, in no particular order, medical records. Mr. Pope, did you get to Ms. Lewis the medical records that we were discussing. And I appreciate it may have been the second time you think you sent them, but my request to you was to identify where in your exhibits, or at least your intended exhibits, you had medical records that you were thinking about admitting. Make sure you got them across to Ms. Lewis. Did you do that?
Oh, no, sir.
Okay, how come?
I didn't, I may have thought I sent it to her. No.
You thought last night you sent them to her?
Yeah, after I checked, I didn't send it. You know, I thought it was a part of my exhibits.
Okay.
Yeah.
I just want to make sure I'm following. You understood yesterday when you left that I had asked you to send them to Ms. Lewis.
Yes.
Okay, but you did not do that.
No, after I checked, I'm saying the exhibits I sent, I looked over them and it wasn't a part of it.
Oh, you went and looked through all the things you had previously provided. They weren't in there, so you're backing off those.
Yes, that's right.
Got it. So no medical records. Again, that doesn't mean you cannot talk about what you experienced.
Oh, yeah.
We've been real clear about that. You can say, I went to a counselor, I went to a doctor, where there may be objections that I would likely sustain would be if you start getting into what the doctor told you.
Right.
Okay, good. Anything, Ms. Lewis, you want to get on the record concerning medical records given Mr. Pope's announcement? Next topic was union reps / shop stewards. And that was of interest to me because we were working through the relevance of Mr. Royal's testimony and Mr. Gresham's testimony.
Sorry, I just want to invoke the rule again. I'm not sure.
Are you Mr. Gresham? Hey, Mr. Gresham, good morning, sir. So unless Mr. Pope has released you as a witness, I need you to wait outside. He will get you soon because he's going to be able to start calling witnesses probably about a half hour or so after we get the jury in here, et cetera. If Mr. Pope has told you you're not testifying, then you're welcome to stay in here. Mr. Pope, what is Mr. Gresham's status?
Oh, yes, he's testifying.
Okay, then we're about to talk about you and your testimony, so I need you to step outside. Thank you. Thank you, Ms. Lewis, for flagging that. So we discussed yesterday afternoon the connection that Mr. Royal and Mr. Gresham might have to Mr. Pope's situation. And what I thought you said to me, Mr. Pope, and I may have misunderstood because I was learning new terms like see me sheet meeting or show me sheet meeting, all these terms unique to life as a MARTA employee. But I thought you told me that Mr. Gresham and Mr. Royal, along with being maybe friends and coworkers and whatnot, they could talk about your situation and your complaints against MARTA because one of them, maybe not both of them, but in different sessions, each of them had been your shop steward or union rep when you had the disciplinary meetings or the show me sheet meetings with MARTA people. Am I remembering correctly that that was their connection to your situation?
Yes, Mr. Royal won't be here today.
Okay, you've excused him?
Yeah.
Okay. All right, so we're back to Mr. Gresham, who is here.
Mr. Gresham, who's here?
Okay, and you're saying that he was present for one or more of the show me sheet meetings you had?
Well, he present to testify.
Okay.
Same as Mr. Gresham, but for personal reason, he's not. From my understanding, he's not coming.
Mr. Royal's not coming.
Yeah.
Well, Mr. Gresham's here.
Yeah.
And if you're going to call him as a witness, I need you to tell me not every word he's going to testify to, but what's he going to talk about generally?
He's going to talk about his service with the company. I have questions.
I'm sure you've got questions.
Anything medical.
Pardon me?
It's not pertaining to anything medical.
Okay.
I understood you yesterday when you told me.
Good. And we got that part. But another thing I told you is that it would not be proper testimony for Mr. Gresham to come in to say, hey, I got mistreated too. I was passed over for promotions or I didn't get a raise. And I think it's because I was older or I was male or whatever discriminatory intent he thinks MARTA had. this isn't his case, it's your case.
And you told me if I said she'll object to it, and you'll object to it.
Well, I won't object. I will exclude it. But
Exclude.
tell me what he's going to talk about your situation, because his situation, let's say he honorably served Marta for 100 years and he got a gold watch and this and that. That's not your case. That's his situation.
He can talk about the criteria when it pertains to job promotion.
Okay.
Yeah.
So he's going to help educate the jurors from his perspective on what it takes to get a promotion, et cetera.
Yes.
He's sort of I'm using this word unofficially, so don't jump out of your seat, Ms. Lewis. He's sort of your expert for the jury, for them to understand how promotions work and how you get evaluated. And he'll be looking at it through the union lens because he was or is a shop steward. Is that a fair summary?
Yes. And he'll be looking at it through just an employee, been there 40 years.
Okay. All right. Ms. Lewis, assuming that is the main area that Mr. Gresham covers, that seems relevant. And he'd be subject to cross-examination in case you find his testimony to be inaccurate because he might not be the supervisor who would be, or the committee that would be making promotion decisions. But it sounds like he would be qualified to explain to jurors how that process works, given his history and connection with Marta. Your thoughts about that, if that's what Mr. Gresham is limited to?
I will subject him to cross-examination, Your Honor.
Okay, and you will certainly be able to do that. I just want to avoid a scenario where you're objecting each question. If Mr. Pope stays in that turf and he establishes that Mr. Gresham has a basis to answer the question, so they're not speculative, things like that, that strikes me as germane to this case and Mr. Pope's complaints. But I think it's important that we're previewing it so you know what's coming. You've had notice that Mr. Gresham was a potential witness and you explained you chose not to depose him. So I feel comfortable going forward that way. I just want to make sure you understand and are not wanting greater clarity before we dive into that.
Well, I don't want to waive any basis for objection with regards to him. I'll be very transparent, Your Honor. He has absolutely no qualifications to speak to promotions as it relates to a journeyman ET, which is what is alleged in this amendment.
Okay, I hear you, and I'm not in asking you. We're going to go forward with this. You waive nothing at all. I just want to avoid setting up, for example, if what Mr. Pope said is that Mr. Gresham is going to talk about my medical condition. You, I suspect right now, would say,
the probation department, and they'll tell you what you need to do with respect to this. I've written in the file that we don't need a full report and the full PSI report. So hopefully you're not required to do the assessment before you go into Veterans Court. I know with our court, you can get it done afterwards. I don't know about Veterans Court. And you're already in it. They probably already have a program set up for you. So I'm thinking that maybe she won't need it before she gets in, but let us know, please, Mr. Bernstein.
I'll email probation when I have answers, Your Honor. Thank you.
Thank you. You're all set, ma'am. Count one is dismissed.
Thank you, Your Honor. Have a great day.
Thank you, you too.
Thank you.
The court will call the matters of Taya Blackman, 20W002696, 21S 00086, 21W 001079, 21W 002850, 22S 000062, 22W 001418, and 20W 3679. We're here for 1, 2, 3, 4, 5, 6 pre-trials and a show cause.
Tiffany Woods for the people.
Paul Barnett on behalf of the township.
Good morning, Your Honor. Attorney Trace McCauley, P number 83499, on behalf of Taya Blackman, present here on Zoom.
Good morning, Ms. Blackman. Please unmute your device, turn on your screen and state your name.
Your Honor, just to let you know, Taya is under the weather. Um, yes, and we'll be proceeding to talk about that a little bit later, but just wanted to let you know that ahead of time that she may have some trouble speaking.
Yes, she also have trouble turning on her camera.
No, her camera should be fine.
Ms. Blackman. She may have been having trouble because she's just back in the waiting room. I'm gonna let her in.
Okay.
There we go. Hello, Taya Blackman. Sorry
Morning.
about that. My
That's
I
okay.
don't know what.
I saw you were having some difficulties.
Yeah, I didn't know what happened.
All right. Where are we with these cases this morning?
So we have spoken to actually I've talked to both Tiffany and Paul. We have made significant payments on to 34 if we were able to clear those suspensions. So Taya is eligible for her license. She made an appointment, however, the branch had to turn her away due to her not being well. She has passed the contagion window. She went in yesterday to get her license and secure it. However, again, that was right inside that window. So today she has set another appointment, and we expect that license will be received later today. We have been assisting Taya for some time. There were a number of things on her license. She has diligently been paying off every court, and we have come to a really great space. We expect everything to be, set and her able to receive again all her license by that time. And then with the intention of getting a car and being able to presume work on a more full-time status. So we're really excited about that. You did talk about a couple of plea agreements, and we are hoping that we can settle with a couple of civil infractions for, let me read out the charges here for,
Are you asking for an adjournment today?
if possible, for a week. That would be amazing, because then we can really bring the court to where we've been trying to this entire time. And this was just very unexpected.
Yeah, I can't do a week, but I can do 3.
Okay, that's fine.
So you're available on June 3rd at 9 a.m.?
Sure.
And the reason I'm doing that, her license does show not valid, which means that she's cleared up the suspensions and it's just a matter of her going to go get the license, just so that the prosecutors know as well.
Perfect, yeah. And yeah, it was just, I mean, this was definitely expected to be perfected today, but this weather has been insane and been affecting everyone. Yeah, so that should work, yes.
June 3rd, 2025 at 9:00 a.m. We'll see everybody then. Bond is continued on all these matters.
Okay, thank you, Your Honor.
You have a good day.
You too.
Thank you, you too.
We'll call the matters of Tahiri Brown, case numbers 25T 00101, 04W5092, and 06W50604.
Paul Barnett on behalf of the township.
Good morning, Your Honor. Tina Sachs on behalf of Tahiri Brown.
Good morning, everyone. Ms. Tahiri Brown, please unmute your device, turn on your screen, ma'am, and state your name.
Tahira Brown.
Tahira, I'm sorry, Ms.
No
Brown.
problem.
I don't think I've written that down. Let me try writing it and see if I get it right next time, if there is a next time. All right. We are here in these matters for a two show causes and a pretrial. Ms. Brown was supposed to make payment prior to this court date. Did you make any payments, ma'am?
Yes, ma'am. I made one payment. I did try to go on to make another payment that I thought that I had to make, but on the system, it told me that there was no citations found. I screenshotted it. I also sent it to my lawyer.
When did
I
you
don't
make?
know if I made the first payment about 2-3 weeks ago, a couple weeks ago.
Must not be our court because it's not showing any payments here that you made, ma'am.
I do have the
I-
screenshot, Your Honor, and it does say 14B court, no tickets found for search criteria. In the search being this court, her last name, and her date of birth.
And I walked the first payment, the one payment I made, I walked into the court and made it.
Into 14B?
Yes, ma'am.
Which street did you go to, ma'am?
Huron, off of Huron and what? No, is that Huron and Whitaker?
Hold on one second.
Here on River Drive.
Okay, she closed the ticket, a whole ticket. So yeah, that is correct. You did make that payment. Thank you, ma'am. But there are two more tickets. And I'm gonna give you the case numbers so that you can find them by the case numbers, okay?
Okay. If I just go in,
Yeah, they can
because
find them.
okay,
Yeah.
because it wasn't working on the website.
System.
I'll go in.
Okay, thank you. All right, where are we with respect to the pretrial in this case?
Your Honor, I was really hoping we would get this resolved today based on the video evidence, but Mr. Barnett indicates that we need to set this for a final settlement conference, and hopefully it'll be resolved then.
Final settlement conference will be on June 27th, 2025 at 9:30 a.m. Jury selection will be on July 11th, 2025 at 8:30 a.m. We'll continue and I'll continue these other matters over to that date as well.
Thank you.
Thank you, Your Honor. Have a great week.
Thank you, you too.
Thank you.
You're welcome.
Thank you, Mr. Barnett.
Yep, sure thing. We'll be in touch.
Okay.
State of Michigan versus Ronald Larry, case number 24S00212.
Tiffany Woods for the people.
Your Honor, Assistant Public Defender Davi Lebo, on behalf of Mr. Larry. Mr. Larry, I believe you stated your name.
Ronald Larry.
Thank you so much. We're here for a pretrial today.
Yes, Your Honor, I'm going to be requesting a date for a motion.
What type of motion, please?
It would be a motion to suppress regarding the stop.
I guess we need a Friday. You said it's at 10:30 already?
Correct, yeah,
Yeah.
9:30 and 10:30.
11:30 on Friday, June 6th work?
Absolutely, Your Honor.
What was that date, Judge?
June 6th at 11:30 a.m.
Thank you.
And you're requesting, you believe you're gonna need testimony from the officers on that day. Is that correct?
I don't necessarily anticipate that, Your Honor.
Okay, because if we do anticipate that, we need to let her know now so she can let the officers know and find out if that date works.
I don't believe so. I think it's something we can do simply based on, well, I guess I would need them for the body camera, but unless the court would be prepared to admit that for these purposes without the officers.
Well, that would be up to the Ms. Woods. You and Ms. Woods should talk about that. And you need to let her know whether she needs officers or not for that particular day.
Certainly, Your Honor.
I mean, the other thing I could do is give you a new date to come back for a pretrial to have it filed, and then we'll know better whether you need the officers or not. Would you prefer that?
Yes, Your Honor, that would be ideal.
Okay. Let's do, so you can have it filed by June 3rd?
Absolutely.
Well, that doesn't really give her time to respond, so.
Your Honor, I could have it filed by the 30th. That would help.
I don't think then that only gives her 3 or 4 days to respond.
Does he
Well-
want to file the motion and then have me respond and then the court give us a date after that, Judge?
No, he doesn't. So I'm gonna have you have it filed by June 3rd, and then she can respond by June 17th.
Thank you.
No, actually, you need to respond by June 16th, Ms. Woods. And I'm gonna put it on for June 25th. I'm sorry, June 17th. So your response, June 3rd, your file by June 3rd, her response by June 16th. Will be here to hear it on June 17th.
Thank you, Your Honor, and I'll discuss this with Ms. Woods to determine if we need the officers present.
Well, we're only gonna have a heard by, so you'll make whatever motions you need, and then I will decide whether we need officers and where we're gonna go with it. I can't make that decision without having the motions, is what the.
That makes sense. Thank you, Your Honor.
So we'll see you June 17th at 11:00 a.m. So that'll be at 11. It's a different time. Okay, sir, because it's a motion and I want to have argument on it, and then we'll go from there, okay?
Okay.
All right, thank you. We'll see you on June 17th at 11 a.m. Bond is continued.
Thank you, Your Honor.
Court will call the case of the state of, well, 1 second. The court will call the matters of John Wayne Russell, case numbers 22-00902, 21W003469, and 22W005866.
Tiffany Woods for the people.
Paul
Mr.
Barnett on
Wilson.
behalf of the township.
Assistant Public Defender Daffy Leba for Mr. Russell. Mr. Russell, could you state your name, sir? Mr. Russell, if you could tap the microphone to get unmuted, please.
He's working. Yes, we can.
Hi, good morning.
Good morning. State your name for me, please, sir.
John Wayne Russell.
Thank you. All right, we're here for a pretrial and 2 show causes.
Yes, with regard to the pretrial, Mr. Russell is getting closer to restoring his license. What he tells me is that where he's at now is that he has 1 ticket left. Unfortunately, that ticket is $750, so he's going to need some time to save up the money to be able to pay that off. However, he does believe that is the only thing that's currently holding his license back.
1 second. That's the ticket out of Ann Arbor.
Yes, 14A1, Your Honor. I have 2 actually right here. It's the same date, but 2 different tickets. One is for 7/26, and the other one is 2/76.
Well, only 1 ticket is suspending your license, sir. So that's the one you need to work on. And have you? It's the
7/26.
I wouldn't know the amount. I only know the ticket numbers.
Oh, yes, ma'am, Your Honor.
So the ticket number is DI11000356 for no proof of insurance.
Yes, Your Honor, I have that.
And what's the cost on that one? Do you know? The no proof of insurance?
$726.
Have you tried to talk to Judge Simpson's or the magistrate out there about setting up a payment plan for you to get your license reinstated?
Yes, I have.
And they said no?
I didn't know what to do. I came to a fork in the road, kind of, Your Honor. I didn't know which one to pay first. But I will, I thought maybe it'd be best I start on the larger amount first, which is the 700, which I planned. I didn't know that ticket existed until I wanted to pay the 2 something.
Okay. Well, I'm not sure I heard your answer because only one is suspending your license. So clearly you need to start with the one that's suspending your license, and that's insurance. My question still is, do you know if they will let you set up a payment plan? Sometime they will let you set up a payment plan and let you reinstate your ticket before you pay it off. Have you asked them to do that?
No, Your Honor.
Well, then I would suggest you call there and ask them if they will give you a payment plan so that you can get your license reinstated. They may say, pay off $250 and then we'll let you buy your clearance fee. That's what you need to ask them. Is there a particular amount?
Tell me what sections they were used. This was not in it. This has nothing to do with the 2 emails you sent me that we were supposed to review that would be utilized at this trial. I just want to enter that. And the other thing I want to enter is an objection, because unless there's an admission against interest, I don't, this would not be admissible.
I assume that Mr. Harbin's entering this is because Mr. James brought up Grandma's Gardens, which I'm guessing that's why he's bringing this up, is because it wasn't even part of the investigation initially, and then Mr. James is the one that, if I'm correct, Mr. Hardman.
Yeah, I mean, obviously it shows Mr. James' relationship with Grandma's Gardens, and it's his statement about how connected he was. it's a statement we provided. I thought that we had provided this portion of this interview. Our focus on from that original conversation was the conversations about Janae, where he specifically talks about the Janae stuff, and that was the portion that we shared with them in response to that email. But there's another, and again, they've had these tapes from the very first original conversation. So,
All right, your objection's noted, so we'll go on.
so looking at we're going to look at the 1 minute and 20 second to 1 minute and 1 20-second.
This culture and here. No. I probably make, I'm gonna guess 27,000 a year from consulting with Grandma's Gardens, and I do everything from, it's really lectures on business culture and how we're going to approach people. How do you compete with big box stores? And so I've designed, they have food days where they invite clients, and it is successful, one of the best in Southwest Ohio. So in this section, I said design a little garden, and that's where you serve your food, so people can find the rest of the piece. And what I do their tax stuff, and QuickBooks, so I stay expert at QuickBooks, but there's no look at it. There's no checks to Grandma's Gardens or.
No,
But he lets me use it. But let me say this.
Gotcha. Well, that makes sense then.
20 people.
So again, at that point, when you met Mr., just to clarify, so that exhibit, that is your voice and Mr. James in that particular interview?
Correct.
And again, at that point, Grandma's Gardens was not a part of your investigation, wasn't something that you had seen or stumbled on as part of any of the documents that you had at that point.
It was not.
This was, just explain how that topic came up as part of your conversation with the defendant.
He just brought it up because he'd mentioned something about Dr. Byers bringing in paperwork, I believe maybe tax paperwork. So that led me to the question about taxes, and he thought I was accusing him of doing taxes. And at the moment, that's not what I was doing. I was just asking, well, does this happen? Do people bring their things? And
Jackson moved to strike what she said he thought.
Sustained.
So the conversation was, when you say taxes, it was bringing taxes to the school in order to be done there. Is that the allegation he was feeling was being brought against? Well, was that the allegation that wasn't the allegation you were investigating? Is that right? Correct. Did Mr. James indicate to you that he felt that was an
Mr. Kendrick? Could you say your name?
Taylor Kendrick. So where are you from?
Me?
I know where he's from. I got all that information. I know where Apple's from. Yeah, you.
I attend Cooley Law School, Your Honor.
You do?
Yes.
Oh, a Michigander or you?
Yes.
What part?
I currently reside in Dexter, Your Honor.
So even a Washtenaw County, Michigan.
Yes, Your Honor.
Where are you originally from?
Oakland County, Holly, Michigan.
Yeah. kind of blew it there. Okay. Where'd you go to undergrad?
Western Michigan.
So you just never left the state?
I actually lived in Chicago for 15 years, Your Honor. So.
Did you?
Mm-hmm.
Didn't like it?
Loved it, but came back for my husband's job.
Oh, he's to blame. All right. Permission to practice is granted. Welcome aboard.
Thank you.
Your Honor, today's date talks about the preliminary examination. At this time, people are unable to proceed as to count one. I would ask that count two be remanded to district court.
You're moving to dismiss count one.
Yes, Your Honor.
People being unable to proceed as to count one is dismissed. I'll maintain the defendant's not guilty plea as to count two. Pretrial in this matter will then be set for
Judge Washington.
June 9th, 2025, 9 a.m. That is before Judge Washington. Thank you.
Thank you.
Bond will continue. Thank you. Court does call the case, People versus Quinard Sanders.
Good morning, Your Honor. Alex Warren Green on behalf of Mr. Sanders. State your name.
Quinard Sanders. I have a plea form in front of me.
Correct, Your Honor. We are going to be proceeding on a guilty plea. Mr. Sanders is currently executing a sentencing judge waiver and the advice of rights form for the court.
All right. Plea form indicates that the defendant will be pleading guilty to an added count 2 of attempted resisting and obstructing a 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. There's further the agreement of no delayed or deferred sentencing. That's the court's full understanding of the agreement.
That's our understanding, Your Honor.
Is that correct, counsel? All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear in the affirmative testimony you're about to give the truth, the whole truth, and nothing but the truth self you got?
Yes, sir.
State your name.
Quinard Sanders. All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Yes.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
Well,
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
no, Your Honor.
Sorry.
No.
Has anybody threatened you or forced?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
On the date of December 17, 2024, at the location 500 West Cross Street, City of Ypsilanti, Washtenaw County, State of Michigan, did you come into contact with a police officer from the Ypsilanti Police Department?
Yes, sir.
What happened?
He asked me to get in the car and I ran.
I'm sorry?
He asked me to get in the car and I ran.
May I have what do, Your Honor?
Pardon?
Ma'am,
Yeah,
what-
go ahead.
Mr. Sanders, you were approached by a uniformed officer on that date at that location, right?
Yes.
And that officer informed you that he was investigating a crime, right?
Yeah.
And you began walking away, right?
Yep.
And he told you to stop.
Yep.
And you ran.
Yes.
Okay. You knew he was a police officer, right?
Yes.
Okay. You don't dispute that he was acting pursuant to his lawful duties, do you?
Nope.
All right. Your Honor, I believe that lays a factual basis.
As the court complied with the court rule, would it be proper to accept this defendant's plea?
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing will be
May 28th at 10 a.m.
May 28, 2025, 10 a.m. before Judge Barr.
Yeah.
Bond will continue.
Thank you, Your Honor.
All right, thank you. Thank you, Mr. Sanders. Court does call the case of People versus Stephen Watson. Pardon?
Mr. Watson.
They got him. Oh, we gotta wait.
We're ready in this matter, Your Honor.
Good morning, Your Honor. Katie Rismersky.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Stephen Watson. Mr. Watson, please state your name for the.
Stephen Watson. All right. What are we doing?
Your Honor, as the court is aware, this time is scheduled for preliminary examination. People are able to proceed this morning. I would anticipate a motion to dismiss the felony. I would be seeking a remand on misdemeanor, but I seek the court's guidance as well. It's charged as a DD first, and it should be a DD second. I apologize to the Court of Counsel, that I do not have a related complaint prepared, but I could move to add count 3 of DD second or amend count 2, whatever the court's preference is.
Oh. Can we? Ms. Zenda is like an expert
I mean,
at getting those amended complaints done. And so I think Ms. Zenda might help you out
I
there.
think she's doing the things right now.
Oh, is she? Okay, see? So what I will do then is, and should we do that? I mean, it's my case, so I'll remember, but should we do that as count 3 or just amending count 2?
Just amend.
Count 2, you think will work? Okay. So we'll just amend count 2 to reflect into DV second.
Wonderful. Thank you.
And you're waiving reading on that?
Yes, Your Honor.
And I'll just indicate that we'll maintain his plea to the amended count 2 in this matter of DV second. Count 1 would be dismissed as people are unable to proceed. I'll set a pretrial in this matter for
May 19th at 1 p.m.
May 19th, 2025, 1 p.m. That's before me.
Thank you, Your Honor. May we address the issue of bond?
Sure.
Honor, my client was out. He had difficulty, and I believe there were issues with.
One could infer that Lieutenant Tully reasonably anticipated these kinds of responses. You know, I don't know if this nut is going to be motivated to go out and try to assist in a car accident or in burning things down. And you know, when somebody says to an audience that Jesus told him, Jesus wants revenge. How does that play? And revenge in the form of somebody being burnt up in the most painful way. You know, Mr. Kearney expresses concern that I gather what Lieutenant Tully is supposed to have done to his children is arrest Mr. Kearney on one occasion pursuant to a warrant at the bus stop after Mr. Kearney brought his children off. If Mr. Bradle had looked at the discovery that the Commonwealth turned over the body cameras of the arrest, he would observe the officers carefully waited for the children to get on the bus and be on their way before their father was arrested. But yet, this is continually held out as a crime, while at the same time, Mr. Kearney has no compunction about wishing death on Lieutenant Tully's children and wife. So, Your Honor, I make those two arguments. One, this was posted with a sure and certain knowledge and intent that it comes to Lieutenant Tully's attention, which in fact has happened. And two, I make the point that a no contact order means no contact. The content, you know, before Your Honor, here's the First Amendment argument. The content of the contact is irrelevant as far as whether there was a violation of the order. And I'd just like to call Your Honor's attention, if I can do it, to a case that I cited in my memorandum to Your Honor. I believe I cited it for another purpose, but it's O'Brien versus Karofsky, at 461 Mass 14. In the course of that case, the court refers to the Cho case on page 424 of the opinion. And it summarizes that case as follows. The defendant produced flyers with the word missing printed in large type across the top, between which was a photograph of a former girlfriend who had broken up with him, and offensive sexual remarks about her. And he then hung the flyers in several places in her high school. He's convicted under a statute which criminally punishes persons with offensive and disorderly acts of language, accosted or annoy persons of the opposite sex. We, that's the appeals court, concluded that the defendant's criminal conviction for this communication did not violate the First Amendment because it was a true threat that had no expressive purpose, but was instead intended to get back at the victim by placing her in fear that she might suffer some sexual harm or wind up among the missing. Your Honor can look a long time, I think, at the language of Mr. Kearney's message in an attempt to distinguish it from the Cho case in terms of the language having no expressive purpose, but instead being intended to get back at Lieutenant Tully by placing him in fear that he or his family might suffer some harm. In fact, what other meaning are we to draw from revenge? Revenge. But apart from that, Your Honor, even if there's some far-fetched First Amendment phrase somewhere lurking in this message, the other material is not protected, and the violation of the order does not consist of the language, but simply the content. Now, the other string in my bow, Your Honor, is the argument that this is again a violation of the intimidation of the witness statute. Mr. Kearney and I have gone back and forth on that statute and how it should be construed and how it should not be construed. Your Honor currently has it under advisement. You see my arguments in my memorandum here with respect to this case. I won't belabor them in full. So I will rest at that point.
Okay. Mr. Bradle, tell me about that word revenge and how am I supposed to interpret that?
Judge, this is not a threat. This is not contact. This is satire. This is all protected. I am so sick of having to come before a court because of Norfolk County and talk about speech that Norfolk County
I do to
doesn't
me,
like.
not to anybody else. Just tell me about that word revenge.
Revenge. Excuse me one second.
Yep, no, take your time. You can confer with your client.
Judge, my client is allowed to have hopes and desires and wishes that you or me or Mr. Cosgrove don't agree with their own life or are repelled by. You know, why do we keep having to come back here? I don't know what it must be like to wake up on the wrong side of the First Amendment every day. This is protected speech, Your Honor, over and over again. The Supreme Court has spoken for decades and decades. Brandenburg, Watts, Chaplinsky, O'Brien v. Borowski, Welch. Judge, this is a waste of this court's time. This is intentional infliction of emotional distress on my client. The Commonwealth has been rebuffed over and over and over on this exact scenario. He is not contacting a witness. He is not threatening a witness. He is talking about someone who has destroyed his life, Your Honor. He is allowed to lash out back. And the First Amendment grants every declarant this room to talk without fear, without the kind of fear that this county has inflicted on Mr. Kearney over and over and over again. And it has to stop, Your Honor. This is First Amendment protected speech. I don't care if we don't like it. I don't care. It doesn't matter. He is not threatening Tully. He is not contacting Tully. He is a reporter with his own style of satire that is addressing a large audience, and he is doing a major service pointing out over and over and over again corruption in this county, perversion of the First Amendment, abuse of the witness intimidation statute, Your Honor. This has got to stop. I don't want to come in here anymore and pretend like, gee whiz, this is a close call. It's not, Your Honor. This is First Amendment protected activity that the court, I have every confidence that this court is going to vindicate. This cannot happen over and over again. I get a motion to destroy my client's liberty 3 hours before every single time they want to do this. I get communications, oh, we're not going to try to revoke his bail. Then I go to Stoughton, they want to revoke his bail. What are they doing? They're corroborating the affidavit we talked about 5 minutes ago, where Jennifer McCabe said, I'm not going to test.
I'm interested in that. I'm interested about the word revenge.
Judge, he can say revenge. He hopes it's revenge on a bad guy that's been destroying him. We cannot engage in this kind of content-based viewpoint discrimination. We don't have to like the viewpoint, but like Voltaire's biographer said, we have to defend to the death his right to say it. And that's all this is, Your Honor, over and over again with this. Excuse me 1 second, please. Your Honor.
Yep.
And Judge, in this context, to address your question, in this context, Judge, revenge means karma. He's not saying, I'm going to go get revenge on you. He's saying that karma's a bitch, is what he's saying, Your Honor. And he's allowed to say that. And this isn't something that is intended to be played on the judge's bench in the formality of the courtroom. This is something that he is talking to his viewers online. And he's allowed to do that, Your Honor. So we have got to stop this charade that this is somehow, gee whiz, we got to lock him up because he's talking and satirizing, engaging in political hyperbole, protected by Watts, Brandenburg. The only thing he can't say are true threats and fighting words. We all know that 100 times over. Why are we here, Your Honor? I ask that you deny the motion and just please issue a ruling that settles this issue once and for all, that this has a chilling effect, Your Honor. Every time we're here, how many journalists do we have in this room?
Okay, I'm up here. Director remarks to me, not to anybody
No,
else.
I'm just looking to see if there's journalists.
No, I'm up here.
There's journalists cover this case. They are experiencing a chilling effect. Am I next? Is the Commonwealth going to go after me next? How far can I go? Can I show up at someone's door and knock on the door? Oh, did I intimidate somebody? Is Norfolk County going to go after me? We don't know. We don't know what they're capable of. And Your Honor, you're the bulwark here. This is the First Amendment we're talking about. We're kicking this around like it's some city ordinance.
Okay.
Thank you, Your Honor.
All right. I'm going to take it under advisement. Mr. Kenny, please stand up. You're walking on kind of thin ice. I'm going to review everything and I'll come out with an order. But I take what Mr. Cosgrove has presented very seriously. I also take into account that there are certain First Amendment rights here as well. And then the issue is always how far does the First Amendment take you and when does it become intimidation of a witness? The word revenge, some of those other words that are on that tape are getting very, very close. So I'll take it all under advisement. Let me just see the lawyers at sidebar.
Thank you.
Now I hate that they got the white noise on, but if you didn't watch with us the other day, Turtle Boy is one of the strongest vigilante investigators of this whole Karen Reed trial. So it's hard to have heard about this trial and not have heard about Turtle Boy. Okay. If you go out to his page out here on YouTube, he has a very strong presence. He's been covering this trial through and through, backwards and forwards, and again doing his own investigations. And so it sounds like, well, we know that he's actually facing tampering charges because he's basically like confronting folks left and right about their participation in this conspiracy to frame Karen Reed. So we're listening in on his hearing right now. And I thought that was interesting, Shay, that Jen McKay said that she wouldn't testify unless Turtle Boy was locked up because she's apparently one of the people that he's been either harassing or trying to tamper with. Another interesting thing is that Turtle Boy allegedly has some type of relationship with Karen Reed. All right. It get real messy over there on Twitter. So I don't want to misspeak, but child, it's giving the Real Housewives of Canton at this point.
Judge, how far out were you contemplating? Give me a day, maybe 5 years.
Could I suggest June 8th? And
So the 20th bill?
So where was the cover? I'm looking here. June 20th, that's a Friday.
Yeah, that's fine.
Yes, I think Mr. Brado and I are supposed to be trying the district court case relative to Mr. Kearney on the 9th of June, which should be concluded on.
Yeah, I would like that.
20th. So that's 2 o'clock or?
Okay, the 20th. Thank you. I'll see you all then. Thank you, Your Honor.
Next thing I'm trying to mention.
Who else are making that? Go right ahead.
Which is like Mr. Brado. I'm
sure you take your.
I'm still going to be back in front of you. Very soon. Doesn't stop.
Okay, Mr. Brado, I'll give you a short response. I'll give you a 30 seconds.
Judge, it's protected activity. That's all there is to it.
Okay,
Thank you.
thank you. All right.
Thank you.
Goodbye.
Yeah. Well, there goes that. So I guess Shay, just let us know if that joint come back on because yeah, that was pretty interesting. That was pretty interesting. We're gonna go back on over to Michigan, listen to the Honorable Judge Cedric Simpson. Yeah, Cedric Simpson. Let's get it back over here.
My client does have employment. He is hoping that the job is maintained for him, but he does not think it will be maintained for too much longer past today's date. The felony charge was dismissed because there is no complaining witness. I expect there will probably not be a complaining witness at the court date as well. Based on that, Your Honor, I'd ask that my client's bond be returned to its previous state. My client has indicated that he will follow all of the strictures of the court. He has learned the importance of not indulging in drug use during any time period. He's asking that he be allowed to have his bond reinstated. The time he has sat in has taught him a valuable lesson.
The problem is that he was testing positive. That's part of the problem. The other part of the problem is he was supposed to then start CCOP and he didn't appear.
I talked to the agent and working a lot of hours. Told me to come to court and signed up for the CLP or whatever, because I can do intensive outpatient treatment.
So, Your Honor, he did have contact. The problem was at the time he was working a lot of hours and he had gone past the time when he should have been reporting. He did speak to the agent. Agent told him to come to court and then he could start getting into the program then. It's not that he doesn't want to. It's not that he intentionally tried to avoid what needs to be done. He set priorities with working and maintaining himself and his family. And that priority, as it turns out, was the incorrect one. He has learned then what the priority should be. And again, it's not like he didn't make contact at all. He did do that. He was working. He'd like to continue to maintain that employment.
Okay, I don't need a response from people. I'm gonna, at this moment, deny your request. I'll look at it again come the 19th. Since it's coming back before me, it's just less than 6 days from now. I'll take a look at it. I would like to see something that's gonna keep him on track, because if he continues to use, doesn't do anything, we're gonna be right back in the same boat. So
I'm not going to use, my job is at risk and I'm for positive drops. And I can guarantee that, I'm just trying to get back to work. My job is.
No, I hear you.
Yeah, just since I really learned my lesson, I understand the importance of not dropping dirty and things like that. And I have learned my lesson. I don't need to be in here. If you give me a chance, I won't let you down. I'm really just trying to get back to work. And
how many times do you think I hear that?
A lot, Your Honor. A lot. And
so tell me what makes you different.
Because I got 6 kids. I got a lot of things going on, and I'm not a person that constantly gets in trouble. I'm done with the drug use. My system is clean, so you have no problems with that. So if I drop today, drop next week before I come to court, everything could come back the same. And you got my word on that.
So if I were to let you out, if I change my mind and I were to let you out, you test dirty or don't follow anything,
I would do the time in jail. But I'm not
gonna do it right now anyway.
Yeah, but I'm not trying to do that. But what I'm saying is I come back and plead guilty to everything. I'm just really trying to get back to work, and you won't have no problems out of me after today.
You need to get yourself set up with some type of outpatient.
Yeah, and that's what I'm saying. If I go to community corrections today, I can sign up for the intensive outpatient treatment, so I can be able to get on the right track. But there will
tell you what, I'm gonna at this moment deny your request. However, if council would contact community corrections, see what they need, I will consider an order to release him with some strict compliance in their program.
See if they have something in place for you. Okay. Oh yeah. Please.
So I'm not saying no forever, but I'm gonna need something that.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
And after that,
you have to turn off center stage. Huh?
Yeah. Sorry.
Just walk in, start throwing things down? What? I'm not, no, too easy. Not gonna say anything. Welcome back. All right. So what are we doing? This one? Got him. Okay. Court calls the case, People versus Timothy Stevens.
Alexander, on behalf of the people, Your Honor.
Oh, you're back.
Student Attorney Kara Rosengren, on behalf of Mr. Stevens, Your Honor. Say your name.
Timothy Stevens. Your name, sir? Timothy Stevens. Thank you.
In your honor, to the concept of preliminary examination, at this time, the people are unable to proceed as to counts 1 and 2, ask that count 3 be remanded to district court.
So you're moving to dismiss counts 1 and 2?
Yes, Your Honor.
Counts 1 and 2 are dismissed. I'll maintain the defendant's not guilty plea as to count 3. Set a pretrial in this matter for June 10th, you said? 5th, 2025, 10 a.m. I'm sorry. 10 a.m. before Judge Fresh Hour.
Thank you.
Yeah, on continue.
Thank you.
Thank you. She's a lot nicer than you, Apple. I just thought I'd throw that out there. Maggie. She didn't give me a lot of argument about stuff. Isn't that true? No? Why, man? It's supposed to. No, she's really not.
Oh, whatever.
She's okay. That's it? That's all we have ready? What are all these people doing here now?
Came to see you.
Is that what you just said? Okay. Well, I guess I'll take a break and wait for more to get ready and then come back. She's leaving? Does she have to go with Apple? I like her better.
Okay. Better?
Okay, better may be the inappropriate word. The dismissal, okay. Get this. Court does call the case, People versus Deborah Gilmore.
Katie Rosmersky for the people.
Yes, Your Honor. Brandon Bird on behalf of Deborah Gilmore. Ms. Gilmore, can you please state your full name for the record?
Deborah Gilmore.
Morning, Your Honor. People are unable to proceed at this point.
All right.
Respectfully request dismissal, Your Honor.
Your Honor, request a remand for this meeting.
All right. People being unable to proceed as to count 1, that is dismissed. I'll maintain the not guilty plea as to count 2. I'll set that for a pretrial on
June 9th at 9 a.m. for the Washington.
June 9th, 2025, 9 a.m.
Yes.
9 a.m. before Judge Wash.
Thank you, Judge.
Thank you, Bond. Go continue. Thank you. Okay. That's it. Okay, then I'll stand in recess and you'll let me know when we're ready on other things. So court's in recess.
All right.
Yeah.
Yeah, y'all absolutely can't hear me. I'm just talking. Okay, so I say it's just a shock to me that we don't have anything to watch today. Not even something good to rewatch. So unless y'all have a suggestion, we're gonna have to call a spade and maybe not stream today, which turns my day into 100% working. I may listen back to court on yesterday. Listen back and can read day 14 a little bit more today. Just because I know I missed a little bit of it while I was working and I didn't rewatch last night. I just kept it moving. But there's nothing out here. What y'all got? What y'all got on y'all radar? He say she just talking and talking and talking and talking. I need to eat breakfast. What I should do is go there and make some breakfast. Ain't nobody here either. I can make me some pancakes. Whoo, I can make me some pancakes, some bacon, and some eggs. Them kids is gone. Them kids is gone. Them kids is gone. So I could go up there and make me some breakfast. It's 9:27. What did my calendar look like? Okay, I got a break between. Okay, I'm going to the gym from 11:30 to 12:30. I'm gonna put a gym break in here at work, so nobody bothers me. And yeah, that's what I'm gonna do. You make me want some pancakes, and let me tell you something about my pancakes. They famous around here. They only get my pancakes on Christmas. Yes, yes. They only get my pancakes on Christmas, or for a birthday. They absolutely love my pancakes around here, and I never make them. But I would make some for me. I don't want to make them for everybody else, though. And by nobody else being here, I really think I could go up there and do the thing. Yes, they don't get pancakes around here. But if I'm making breakfast, 9 times out of 10, they eating rice, sausage, and eggs. But when it come to pancakes, I don't make them. I don't make them. I had pancakes last night, believe it or not. I haven't made them in years. Yep. Let me tell you why I don't make pancakes, Shay. I don't make pancakes because when I first, well, I ain't gonna say when I first got with Nick, but when we had our son, I was breastfeeding, and so I used to eat nonstop like a garbage disposal, like nonstop. And I literally made pancakes every day, every single day for about 6 months straight. And it became overwhelming after a while because like people were waking up expecting pancakes, and it was an expectation that they were getting pancakes. And so when I stopped making them, I stopped making them, and I don't make them no more. And that's been what, 4 years? My son will be 6 this year, so it's been about 5 years, close to 5 years. Every day it's extreme. I know, very much. And so now I don't make them. I only make them on Christmas, and I'll make them on a birthday. But if it ain't that, baby, no. Baby, now Nick can make some pancakes. His pancakes ain't like mine though. His pancakes ain't my pancakes. He don't even know how to get that crust. You know what I mean? He don't know how to get the crust on that pancake. So I don't even eat his. So yeah, that's kind of where we landed. But yeah, I don't make pancakes anymore. But I can make me some today, or I can go make me a waffle. I can bust out the waffle maker and make me a waffle. All right, y'all. So I don't think we got anything to watch. You gotta have a crust, absolutely. I don't think we got nothing to watch, y'all. So we may just call it today and pick back up on the trial. Wait a minute. Judge McBurney's still in his courtroom. Let's see what he's talking about. His mic aggravates the hell out of me. Wait a minute. His mic was aggravating the hell out of me today. Oh, they saying it's a struggle and all type of stuff. I don't know, y'all. It ain't feeling good. So I'm gonna just go ahead and end the stream. I'm gonna do some work. I'm gonna make me some breakfast. I could eat me some tacos from last night because I made tacos last night. I don't know, y'all. But I will see y'all later. Thank y'all for tapping in. If you're a part of the Taylor game, I did drop a YNW Melly video, not only here on YouTube, but I also did it on TikTok. So if you are a part of my TikTok family, make sure that you like, comment, and repost the video. Make sure they keep y'all girl in the algorithm. I'm gonna go live over on TikTok in a few minutes too, just to see what's going on, see what's up with the folks over there. So I hope y'all have a good Tuesday. Enjoy the day. Hopefully we hear back from our law school today. Hopefully we hear back from the school of our choice. They did something with our application on yesterday. So it's feeling, I don't know, I still feel good about it. I'm going to continue to feel good about it until I have nothing to feel good about. So thank you for tuning in with us today, and I will see y'all tomorrow.